Agency.
My Lords.
Yes, Mr. Logan.
My Lords, I take it that the court is aware of the appearances for the appellant,
Yes.
the respondent, and the interested party today. Before I proceed, there are a couple housekeeping matters.
Yep.
We have passed up a couple documents which comprise the following. You would find a revised case for the appellant with references to the electronic bundle. Although this requirement was dispensed with, it's normally required, and we thought if it might be of assistance to your lordships, we will pass it up. The second would be a list of references for two issues which my learned friend Mr. Wald will cover, and they are references that in the order in which his submissions will go. Number three would be a bundle of clean plans, which, as you'd appreciate from the record, were not as legible and clear as one would like them to be.
We had those as an election.
Yes. It's enlarged, and I think it's the best quality out of all the plans that we have. I know the respondent did, in fact, attach some, but this is a little bigger and it's a little clearer, hopefully. Yes. Number four would be a judgment from the Court of Appeal for Justice of Appeal Kangaloo, which is referenced in the case for the appellant, but was inadvertently omitted from the joint bundle of authorities. Yes. And number five would be the EasyJet case, which again was referred to in the case for the appellant, but was omitted from the bundle. And number six would be the National Environmental Policy, to which reference again was made in the case for the appellant. In other words, there's nothing new that we've added. These are all matters that might have been, would have been referred to in the case for the appellant. Yeah. And my lords, still on housekeeping, we received some authorities and some documents from my learned friend for the respondent. Yeah. Some 10 documents. What we have, by way of exchange of emails with the registrar, subsequent to that, we have spoken, and my learned friend, Mr. Knox, has indicated that he has no objection, subject, of course, to the board's approval, that we can be permitted to put in a short written reply, if necessary, to those authorities in the event that he relies upon them today.
Yes. The difficulty with that suggestion is that if we do that, then the board cannot give a decision today.
Sure.
Which might otherwise, depending on how things go, obviously, it might otherwise have been a possibility.
I understand, my lord. Well, in that case, I'm certain my learned friend, Mr. Knox, would be perhaps a little more cautious about referencing those authorities.
Yeah. If I can insist, there are really only three very short authorities which I really want to know, which is how did Rule 56.5 come into existence and what was there before? Yes. So that one can see the context in which one has to construe Section 11 of the Judicial Review Act.
Yes.
And they're literally sort of 2 pages each, I think, more or less. So you can just see the sequence. You can see what was there before Rule 56.5, which came into effect in 2006. And it's just a series of little notes from the notices, which explain how each of the variations was made.
Do
just
we really
3.
want to know?
Well,
I mean,
it may be.
It tends to confuse rather than assist.
Well, one point in the case is there's a difference between Rule 56.5 and Section 11.1 to 4. And this is simply to explain how that difference came about and why, in my submission, it shouldn't make any difference at all.
Yes. Yes, Mr. Logan, is there a difficulty about our looking at those specific documents?
No. In terms of the chronology of the rule of court, Part 56, I have no difficulty with that. Right. It's the cases, my lord, that I have a problem with because we just simply haven't had an opportunity to consider them carefully. Yes. We only received them last night. Yeah. So, my lord, if I may now commence, my lord, this is an appeal against a refusal of permission with respect to a challenge against a decision to grant a certificate of clearance concerning the construction of a 5-kilometer highway which is part of a larger 32.5-kilometer highway scheme. It passes in the vicinity of an environmentally sensitive area that is highly protected by virtue of several legal orders, but it's the highest form of legal protection that one can give to an environmentally sensitive area. Now, my Lord, during the course of case management for this appeal, we were advised by your board's registrar that this appeal will be confined to a refusal of permission. Yes. I therefore don't intend to trouble the board to go beyond what is necessary to prove that permission was wrongly refused. It is in those circumstances, my Lord, that the history of the proceedings would perhaps bear some relevance. And the history of the proceedings would reveal that the Court of Appeal, a panel differently constituted, in granting leave to come to this board, had fundamental differences of opinion with the panel that heard the substantive appeal. And as a result of that, not only was leave granted after a hotly contested, opposed application for leave to come to this board, but also a consequential interim injunction was granted pending the hearing and determination of this appeal. Now, my Lord, I noticed that my learned friends say that in a case where there is an application for leave and an application for injunctive relief, that there should somehow be a different test to be applied. We say that those are two different concepts. One should be careful about conflating them, because it is possible to seek leave to apply for judicial review without necessarily pursuing an injunction. And even if one could not resist the temptation to conflate those two concepts, we say in this case, we meet the threshold either way. In other words, there is ample judicial dicta from the courts below, as well as serious merits to have serious triable issues, which will be the first hurdle in the American Cyanamide test before one gets to the balance of convenience or balance of justice. And we say that is perhaps resonant with the Sharman-Brown-Antoine test of serious issues to be tried with a realistic prospect of success. It may be that there's a distinction without a difference. My Lords, we do say, however, that one should bear cautiously on the idea that the inability to give an undertaking in damages in public interest litigation and public law matters is one that should be applied, as it were, in private law cases, simply because it raises serious questions about access to justice. It has an air of risky judicial elitism about it, because the irony is that those who need access to justice the most and are least able to give an undertaking in damages are perhaps the ones who will be denied access to justice the most. And furthermore, as this case amply demonstrates, there may be public interest cases where there is no list between the parties, but what is at stake is genuinely a matter that concerns the public at large, and in this case, not just the public in Trinidad, but the environment as a whole. And given the fluctuating weather patterns I've personally experienced in the last 4 days in London, I dare say we should take note, my Lord.
How important is the injunction issue? Because if we were to decide that there's a serious point of law which justifies granting permission, I would be slightly surprised if the government were then going to proceed with the road until that has been decided. But normally in these cases, if one doesn't then need to get to the stage of an injunction, because the grant of leave and from this board, I would have thought might be enough. But we'll obviously hear what Mr. Knox says. But.
Yeah, well, I would hope not, save and except that in the courts below, during the brief periods of interregnum, when there was no protection by way of an interim injunction, that's precisely what happened. Yeah. They attempted to actually commence works in a very accelerated manner, and that's when we promptly
got the injunction restored. But I understand that, but we're now in the Privy Council, and in either way, you would accept there's an important public interest in this road being progressed if it's lawful. I mean, it has a public interest in itself, so you're balancing two important public interests.
I accept that, my Lord. And the injunction would expire upon delivery of judgment by this board, which is why we don't seek to trouble you on this appeal with that, because the necessity for the injunction arises if leave is granted and not otherwise. My lords, you would have seen that of the 7 judges who would have considered this matter, 5 of them take the view that the appellant's case raises serious issues that are arguable with realistic prospects of success. You would also note that although the Court of Appeal in granting leave focused on 4 main or primary issues, that in the order granting leave, there was no restriction on the appellant. And I say this to make it plain that the appellant does not abandon the other grounds, but we will, for the purpose of this appeal, focus on the primary grounds outlined in the judgment of Justice Narayan. There are 4 issues in this appeal. Firstly, whether the refusal to extend time for the filing of the application for leave whether that was wrongly refused, and if so, whether time should be extended. The Rule 5.2 of the CEC pre-TOR consultation point, whether the EMA was entitled to grant the certificate of clearance in the absence of a cumulative impact assessment, and whether it was rational, number 4, whether it was rational for them to grant the CEC with conditions given the weight and seriousness of the objections by the internal staff. I will deal with the first 2, and Junior Counsel Mr. Ward will deal with the latter 2. My lords, I briefly wish to take you to the statutory framework, which you will find in Volume 13. And the purpose for so doing is to establish the emphasis on public participation and public consultation, which permeates the legislation at every twist and turn. Lords, if I may take you to Volume 13 firstly. To the Act, which you will find, if we take it from page 5791, page 5785. And this is the Parent Act. You'll see at page 5785, the objects of the Act are to promote and encourage among all persons a better understanding and appreciation of the environment, encourage the integration of environmental concerns into private and public decisions. C, ensure the establishment of an integrated environmental management system in which the authority, in consultation with other persons, determines priorities and facilitates coordination among governmental entities to effectively harmonize activities designed to protect and enhance and conserve the environment. And of course, the interested party, the Ministry of Works and NIDCO, would be governmental entities. To develop and effectively implement written policies, laws, and other programs in relation to the conservation and wise use of the environment, to provide adequately for meeting the needs of present and future generations and enhancing the quality of life. The government's commitment to economic growth and the government's international obligations. At page 5787, you will see how the board is appointed. The president appoints the chairman and the members of the board, but in so doing, he acts on the advice of the government, the cabinet. And that is pursuant to Section 80 of the Constitution of Trinidad and Tobago. So it is not that this is a non-politically appointed board. The board is a politically appointed entity. And the board that is politically appointed, in turn, appoints the managing director, which you will see at subsection 3. I take you to page 5791 to the functions and powers of the authority. And you will see section 16, to make recommendations for a national environment policy, which I'll come to in a bit, to develop and implement policies and programs for the effective management and wise use of the environment, to coordinate environmental management functions performed by persons in Trinidad and Tobago, F, to develop and establish national environmental standards. G, monitor compliance with the standards criteria and programs relating to the environment. Subsection 2, in performing its functions, the authority shall facilitate cooperation among persons and manage the environment in a manner which fosters participation and promotes consensus. Section 18, the board shall prepare and submit to the minister, not later than 2 years after the commencement of this act, a national environment policy, which I will briefly take you to show you that even in the national environment policy, public participation and public consultation is at the forefront of the draftsman. At 5794, subsection 3 at the bottom of the page, after considering the recommendations and report developed by the board, the minister shall cause a draft policy to be prepared by the board and submitted for public comment in accordance with section 28. After considering public comments received on the draft policy, the board shall submit a revised draft policy to the minister for approval. At page 5800, you will see that the minister may make rules, and at H, the procedure to be followed by any person required to apply for and receive a certificate of environmental clearance. At section 27, he will submit the draft rules for public comment in accordance with section 28, and he will consider the public comments received and revise them as he thinks fit. At section 28, it again emphasizes the need for public consultation. And at section 35 on page 5805, you will see that listed activities that are specially designated must require a certificate of clearance, which in this case applies. And at page 5806, subsection 5, any application which requires the preparation of an EIA shall be submitted for public comment in accordance with section 28 of the Act. After considering all relevant matters, including comments and representations made during the comment period, the authority shall issue a certificate of clearance. Now, my lords, if I take you next to...
Can you just help me on section 30?
Section 30?
Yes, there's a provision for an appeal to the Commission by any interested person.
Yes, my lord, there is the possibility of an appeal, save and except at the material time the Environmental Commission was not in existence.
Is that right?
It is.
I see. So who do you appeal to?
Well, the board. Because we could, you could come back, judicial, it was not an alternative remedy. The board... No,
that was what I was wondering, because
yes.
You weren't an interested person in the sense that you hadn't
yes.
submitted written comment. Would you say that it's not an alternative remedy because there isn't a commission to appeal to?
No, it was not constituted, so it was not in existence.
Right, thank you.
My lords, in the interest of time, I think I will briefly just say this. When one looks at the National Environment Policy, you look at the Act, and you look at the CEC rules. The importance of public consultation and public participation in the management of the environment and the protection of the environment could not be greater and more at the forefront of all of the entire statutory framework that governs the management of the environment in Trinidad and Tobago. Now, my lords, I shan't trouble you with that point further, but I think reference is made in the case to the appellant adequately to that. My lord, that brings me to the next point about the importance of these savannas to Trinidad and Tobago and indeed the world at large. I take the volume 13, to the Canary Management Plan. Volume 13, Canary Plan. 13, please. Volume 13. Volume 13. Oh, right.
Is it? Thank you, Ben.
Yeah, that's fine. Hello, it's volume 6, I beg your pardon.
Do you have a page reference?
Yes, I do, my lord. It's 2420, 2420. And this is the ESA management plan for the savannas, dated July 2008. And a couple of quick points I'd like to make. It's volume 6, I'm on page 2432. You will see that this plan, my lord, which has statutory recognition and force because it is made pursuant to the Act and regulations, you will see that the plan, it says at page 2432, it's for long-term direction and resource stewardship and ultimately management of the AESA, and it's to last from 10 to 15 years. That 10 to 15 year period is important because it covers the present time, and there has been no other plan. At page 2434, you will see the role and significance of these savannas. I won't read it, my lord, but I will ask you to take special note of it because it provides the justification for the high level of environmental protection, including the fact that it is an area reserved for scientific research internationally, and that it has long been recognized as an important part of our environment deserving of the highest form of protection. I take it to page 2453, where way back when this plan was done, in the year 2008, at page 2453, you will see that the highway was mentioned. So this highway is nothing new.
Which page was that?
2453, my lord.
Okay.
And you will see a buffer zone of 100 meters was mentioned to the Canary team of experts. And this is what they said at the bottom of 3.61. The construction of the highway may result in ecological isolation of the ESA from the forest areas to the south, which are the only remaining significant forest resource management, forest are still connected to the ESA. And this is discussed further in the resource management plan. It is against that backdrop at page 2459 that you will see the recommendation in relation to the highway. You will see management zones section 5, and if I just read the last paragraph, the buffer zone is a natural or semi-natural habitat surrounding the core of a reserve. Its purpose is to reduce external influences. Ideally, a buffer zone should have been zoned within the ESA, but given its small size, it's not a viable option. Instead, the proposed buffer zone would extend 500 meters outwards from the boundary of the ESA and will have a landscape plan developed in collaboration with all adjacent landowners. It must be emphasized that this proposed buffer zone does not have any legal designation currently, but would encourage good neighbor practices on the surrounding lands. So it is clear that a 500-meter buffer zone in a plan commissioned by the Environmental Management Authority, in a plan that has a statutory foundation, given that it flows from the protection, the legal orders that were made to protect the savannas, and it's still current, given its lifespan.
Come on and see where the buffer zone is on a plan.
Can we see where the buffer zone is on the plan, my lord? Can I leave that to my friend, Mr. Wall, to show the board when he, I'm obliged. My lord, I go next to the question of leave.
Yes, no, I'm just trying to understand the buffer zone.
I'm obliged, my lord.
And the relationship to the highway.
Sure. Now, my lord, the Canary Management Plan is the subject of a factual dispute. The factual dispute is Dr. Jyot Singh, who is a renowned academic and a former CEO of the Environmental Management Authority, and who was there at the material time, is on affidavit as saying that this plan was accepted as the official policy for the EMA, which is why its lifespan is so important. The present CEO, his successor, Mr. Romano, disputes that, but doesn't condescend in his evidence to provide details as to what's the status of the plan, why they did not adopt it, having obviously commissioned it at great expense. And that is a factual issue that is rather central to the case of the appellant, which we say could not be easily determined at the leave stage one way or the other. Now, my lord,
how does the plan, I mean, there isn't an allegation of breach of the plan, is there?
Well, yes, because the breaches, insofar as they've gone for a 100-meter buffer zone and jettisoned the recommended 500-meter buffer zone from the Canary report, that would have required some form of explanation, my lord, and credible explanation.
I may not have picked, I didn't understand that to be one of the grounds of the judicial review, but I may have missed it.
Oh, yes, my lord, the buffer zone features in the grounds.
Right, yeah, okay,
yes,
well, we'll come to that.
Yes, please, my lord. Now, my lord, on the question of leave, historically, leave was meant as a filter to keep out cranks, busybodies, and to weed out wholly unmeritorious cases. If there was a knockout punch, it's delivered at the leave stage on a quick perusal of the papers to see if the case raises issues that are capable or worthy of argument. And then that function at the leave stage, my lord, to protect public authorities from unmeritorious claims, we had a development with respect to the judgment of the board in Sharma versus Brown Antwine. And that judgment, the test was one that perhaps created some difficulty in the way it was interpreted and applied back home. It was interpreted as elevating the height of the hurdle for the grant of leave. And, my lord, in tandem with that was the radiating effect of the development in constitutional jurisprudence, which saw judicial review as the cradle for the rule of law, and its role in vindicating the rule of law as being of paramount importance. Now, in a country where the Constitution is the written Constitution is the supreme law, it obviously collides with the exercise of executive power in a way that demands constant vigilance and supervision by the judicial arm of the state. It is against that backdrop I'd like to take, my lords, to the Court of Appeal's attempt to contextualize the development in Sharma and Brown Antwine. And I take you to volume 16. Yeah. Firstly, to volume 16, page 6721. This was an appeal against the refusal of permission, which is where we are before the board. And at page 6721, Justice of Appeal Mendonça says, before discussing these grounds, it is important to emphasize that this is an appeal from the refusal of leave to apply for judicial review. It's not an appeal from a final determination of the matter after a full hearing. The hurdle that the appellants must overcome is not a very high one. What the appellants need to show in order to obtain leave is an arguable ground for judicial review having a realistic prospect of success, and there is no discretionary bar, such as delay or alternative remedy. No such discretionary bar was advanced here. The appellants having established an arguable ground of appeal for judicial review, having a realistic prospect of success. The judge was wrong to refuse leave. They granted leave. Can I take you to the second judgment in this? It's a loose leaf one. The second judgment in that very case. It's the loose leaf judgment that was omitted, and it's the judgment of Justice of Appeal Kangaloo. It's the Steve Ferguson and Ishwal Galbaranson case. At paragraph 2, Justice of Appeal Kangaloo recites from the judgment in Sharma and Brown Antwine.
Mr. Ramlogan, can we just orientate ourselves?
Yes.
We've been looking at a Court of Appeal judgment from Justice of Appeal Mendonca,
yes, please,
17th December 2010.
Indeed.
You now want us to look at other judgments of the same date in the same case?
It is another judgment from another judge in the very same appeal.
I see. Right, which we don't have in 16 for some reason.
Yes,
Okay.
I apologize. So it's a loose leaf one.
Thank you.
So, my lord, this is Justice of Appeal Kangaloo who gives an additional judgment to Justice Mendonca to complement what he said. And he says he's read the judgment of Mendonca, but he wishes to make a few observations at paragraph 1, which he believes will assist in the future development of the law of judicial review in this jurisdiction. And he says, he quotes Sharma and Brown Antwine, the ordinary rule is that the court will now refuse leave unless it's satisfied there is an arguable ground for judicial review having a realistic prospect of success and not subject to discretionary bars. But arguability cannot be judged without reference to the nature and gravity of the issue to be argued. It is a test which is flexible in its application. That caveat has been somewhat underappreciated. My lord, he goes on in paragraph 3. In analyzing this formulation of principles governing leave applications, it's important to bear in mind the factual background against which this test was enunciated. The issues raised in the Sharma case, although quite serious to the applicant, essentially were a challenge to the prosecutorial decision of the acting DPP. To successfully challenge such a decision is decidedly difficult, and as a result, the application for leave failed. I believe these factors weighed heavily in the minds of their lordships in their disposition of that case. The test of arguability must be applied contextually and cannot be divorced from the nature of the challenge which is raised by the litigant. It would be a travesty if the words of their lordships were taken to mean that the test of arguability lends itself to stringent application. To adopt such an approach would erode the very protection offered by the remedy of judicial review, which is to keep the executive in check and prevent arbitrary, unwanted, and unlawful executive action. Such protections are part of the wider concept of the rule of law, and he cites Lord Phillips. Paragraph 5, the main purpose of the permission stage in judicial review is to eliminate unmeritorious applications brought by an applicant who is no more than a meddlesome busybody, an aim which is particularly beneficial in current times. However, in fulfilling its mandate as guardians of democracy and the rule of law, concepts which can be easily seen as two sides of the same coin, the court must not lightly refuse a litigant permission to apply for judicial review. It must only be in wholly unmeritorious cases which are patently unarguable, barring delay and alternative remedy, that the court should refuse leave. My lord, I think what Justice Kangaloo was attempting to do is to pull it back a little from the ledge. And the reason being, Sharma and Brown Antwine was a challenge by a sitting Chief Justice to a DPP's decision to prosecute.
Yes, it's a different case. But surely, this is a very different case, again, because here you've got what you didn't have in those cases, which is a public interest in the construction of a major project. So there's always a balance.
Indeed.
And so the threshold of arguability may vary according to the subject.
Indeed, my Lord.
I mean, here you've got to show a serious point.
Indeed,
That's what you're hoping to do.
Indeed. My Lords, moving on, this is a case you will see from our Judicial Review Act. It makes provision for public interest litigation. And if I take you to section 7.7 of that act, you will see it's at volume 13, and you will see from the intitulment of this action that it's a claim brought in the public interest under section 5.2b of the Judicial Review Act. And section 7.7, I think, codifies the criteria that the court should, page 5733, volume 13, 5733, I beg your pardon, Lord. It's at the very front.
Thank you.
So it starts at 5732, section 7. In determining whether an application is justifiable in the public interest, the court may take into account any relevant factor, including A, the need to exclude the mere busybody, B, the importance of vindicating the rule of law, C, the importance of the issue raised, D, the genuine interests of the applicant in the matter, E, the expertise of the applicant and the applicant's ability to adequately present the case, and F, the nature of the decision against which relief is sought. And these factors, we say, lend credence to our argument that in dealing with the question of leave, it is not as simple as looking at a delay in a vacuum without reference to what we say are obvious relevant factors. And those factors are relevant whether it's a claim filed in the public interest as a public interest litigant, or it's a claim that raises matters in the public interest, serious issues in the public interest. The procedure would not really matter. It is the substance of the issues raised in the case.
But this is about standing, isn't it? I mean, we see from section 5.2 that there's a contrast between someone whose interests are adversely affected and then someone who, like you, who's bringing it in the public interest. And standing is dealt with in different days in different jurisdictions. But here you have a very helpful summary of the issues.
Indeed, my Lord.
But that's quite apart from the question of whether you should get leave anyway on the merits of the case.
That's true, my Lord, but we do say that those would be relevant factors that should feature in the exercise of judicial discretion when one considers whether leave should be granted in a case that plainly raises issues in the public interest. Now, my Lords, at the heart of this case, one of the major contentions is the correct interpretation of Section 11 of the Judicial Review Act. And my Lords, you will find that in the same volume 13, at the very front, and you will see Section 11 at page 5734. And my Lords, the respondents and the interested party take the view that this is a hurdled or tiered approach, and they take a very blinkered and compartmentalized approach to the interpretation of Section 11, whereby if you don't cross the first hurdle, then you don't get to the second one, and so forth. We say it's a single composite test, and that is the wrong approach. We say that it's a single decision as to whether you should extend time and grant leave or not. And this guide to the exercise of that discretion, which must be viewed more along a continuum rather than a hurdled approach. And we say that, my Lord, because when one looks at the section, we see Section 11.1, an application for judicial review shall be made promptly. I think that means really an application for leave, not an application for judicial review, shall be made promptly and in any event within 3 months from the date when the grounds for the application first arose. It's important and interesting that it doesn't say 3 months from the date of the decision. It says 3 months from the date when the grounds for the application first arose, unless the court considers there is good reason for extending the period within which the application shall be made. Now, my Lord, it's not that there should be good reason for the delay. It's that there should be good reason for extending the period within which the application shall be made. Now, my Lord, at this first stage, whether there is good reason to extend the time, we say the court must have regard to relevant considerations. For example, if there is an absence of prejudice and detriment, that is obviously a matter that should enter the judicial equation at that first stage. The respondents take the view, as you will see from my learned friend Mr. Knox's case, that it doesn't enter the picture frame. That prejudice and detriment are questions that you get to only if you clear the first hurdle, so that it cannot form part of the 11.1 analysis. We disagree. We say that plainly the exercise of judicial discretion will have to have regard to any and all relevant considerations. In subsection 2, if there's been undue delay, you can refuse leave if the grant of relief will cause hardship and prejudice the rights of any person or would be detrimental to good public administration. Now, we say, my Lord, that these are matters that these are not matters, as the respondents put it, that can only be considered in the exercise of what they term a residual discretion. In other words, if you don't get past hurdle 1, this is another reason that they can invoke, that the court can invoke to deny you leave. They take a negative and restrictive view of it. We say that's not the correct approach. We say the correct way is simply that there are plainly relevant considerations that the court must bear in mind. And if there is no prejudice and detriment, then one would expect that that would weigh in favor of the grant of leave.
But I mean, are you saying that you read 1 and 2 together, in effect?
We say read section 11 as a whole.
Well 11.1 is laying down a mandatory requirement. An application shall be made promptly. And then there's a proviso enabling the court to extend the period. 11.2 is dealing with the grant of leave, which is not a separate, with a discretion, in fact, in relation to the grant of leave. Is that not a separate question?
Well, Lord, it might be, but the point is that in exercising the discretion to extend time on the 1, the absence of prejudice and detriment may also feature as a relevant consideration for the court, because it would be the absence of prejudice and detriment would be a good reason to extend the time for the filing of the application for leave in its own right. It would also be relevant to the question of the grant of leave, yes, but it is not irrelevant to the question of whether time should be extended under 11.1. That's why I say, my Lord, that the sections are interlocking, interwoven, and perhaps interdependent. Yes. And that's why it should be viewed as a whole.
Are there not perhaps two different approaches here that we're at risk of confusing? One is to say that the relevant considerations under 11.1 may overlap with the considerations listed in 11.2. That's one thing.
Indeed.
Another thing is to say that really 11.1 and 2 are provisions which should be rolled up so that the court takes a single decision reflecting both of those provisions.
Indeed, my Lord. Indeed. And we say that one should not approach this wearing blinkers, saying, 11.1 can be looked at to the statutory exclusion of any other relevant consideration. And we're fortified in saying that because when you look at 11.3, it says informing an opinion for the purpose not of a subsection, but informing an opinion for the purpose of this section, i.e. the section as a whole, the court shall have regard to the time when the applicant became aware of making of the decision and to have regard to such other matters as it considers relevant. So, my Lord, we say it's obvious that that these are matters that should be upon the court's mind in any event. Now, my Lord, if I may take you briefly to the case law that deals with the extension of time, and I take you to volume 13. And my Lord, I should mention that the case relied upon by the Court of Appeal of Devon Barrage and the National Energy Corporation, that is a case which is on appeal before the board. Mr. Michael Fordham, Queen's Counsel, leads me in that appeal, which is fixed for hearing on October 31st. And because it arises in this appeal, which is sort of like a curtain raiser in many respects and a prelude to that, I mention it because the board may wish to consider if there are any implications for the administration of justice, given that that appeal is fixed, whether perhaps the same panel may sit, or whether judgment should be deferred until such time as that appeal is heard, and it's not very far off. Now, my lords, if I take you to volume 13 and to page 5856. You will see at page 5856 that this is a unanimous judgment of the Court of Appeal, and it comprised Justice of Appeal Kangaloo, Justice of Appeal Mujamada, and Justice of Appeal Weeks. Justice of Appeal Weeks is now our head of state, having been appointed President of the Republic. And at page 5856, the Court of Appeal outlined section 11 and said, I am therefore fortified from the legislative scheme. It's clear that it is only if both undue delay and prejudice or detriment that the court may refuse to grant leave. So they were of the view that both prejudice and detriment must exist in order for the court to refuse leave. I'm fortified in my opinion that delay alone without prejudice or detriment is not sufficient to preclude an otherwise worthy application of permission. Similarly, when the rules are looked at, Rule 56.3 shows that when a court
where do they get that from?
Beg your pardon, Lord? It's 5856.
Yes, I got that.
That's the conclusion and finding of the court.
He says the scheme is clear that it's only if there's both undue delay, and that's effectively on the basis of putting 11.1 and 2 together.
That's correct. That's correct, my Lord. That's correct. This is the Absal Mohammed judgment. And, my Lord, he says, with respect to the rules, he says, when one looks at Rule 56.3, it shows that when the court is considering whether to refuse leave on the ground of delay, it must consider whether the grant of leave would be likely to cause hardship or prejudice. The rule demonstrates that delay alone is not the deciding factor on whether to refuse leave. And at paragraphs 24, 25, and 26, in 25, what amounts to good reason to extend time is a subject of much debate. It's sufficient to say the factors to be taken into account are the length of the delay, the reason for the delay, the prospect of success, degree of prejudice, overriding principle that justice is to be done, the importance of the issues involved in the challenge, and he cites ex parte agi, and it suggests that even in an exceptional case, the court may entertain judicial review even though the claimant has failed to show a good reason for extending time. What the court said is, delay simpliciter ought not to defeat an application for a judicial review where other important considerations feature and loom large. It would be wrong to look at delay in a vacuum without reference to the issues raised and the need to vindicate the rule of law. I take you next, my lord, to Devant Mirage, which you'll find in the same volume 13 and at page 5894. No, sorry, this is volume 15, yes. Devant Mirage. I actually turn to page 5898. And this is the judgment that is on appeal to the board in October, but it is also the judgment that is relied upon in the Court of Appeal, because the judge who gave the lead judgment, Justice of Appeal Smith, in Devant Mirage, happened to be the president of the panel that heard the instant appeal before your lordships. And, my lords, I'll ask you to have regard to the reasoning, but the reasoning essentially is paragraphs 24 to 27. And what he says is at paragraph 24, if a court must also consider prejudice and detriment before refusing leave, then the time of the application for leave is no longer a material factor, since issues of prejudice and detriment will override delay or any time limit for making the application for leave. He did not seem impressed that a lack of prejudice or detriment can nullify the delay. He then says, secondly, in paragraph 25, he cites the Afzal Mohammed, and he says, even if an applicant fails to provide a good reason for delay, a judge will be unable to refuse leave if there is no prejudice or detriment, and hence he will of necessity have to extend the time for applying for leave. Now, my lords, we do not go so far as to say that, look, if there is an absence of prejudice and detriment, then there is an absolute rule that you must get leave. We don't make that submission. We go so far as to say that these are highly material and relevant considerations to the exercise of judicial discretion in whether to grant leave or not. In other words, they should be in the picture frame in the judge's mind. And then he says at paragraph 26, his interpretation is consistent with Fishermen and Friends, and he uses the words residual discretion, and then he says he thinks that the Afzal Mohammed judgment was per incurium, and he points out in paragraph 27 that if you had to consider prejudice and detriment at the ex parte leave stage, it might be somewhat difficult. But that ignores some important considerations. That's at paragraph 27. And my lord, at paragraph 27, he says, at the ex parte stage in an application for leave, you might not have evidence of prejudice and detriment, but my lord, you will have the response to the pre-action letter, which, if properly done in accordance with the pre-action protocol practice direction, will give you sufficient information. B, you can call for further information and have an inter partes hearing, and you can allow evidence if necessary. C, you can grant leave, and there can be an application to set aside the grant of leave if necessary. And, of course, a judge can, in fact, ask for further information if necessary. I take you to page 5904. It's the second judgment in that very same case of Devant Mirage at page 5904. Justice Barrow in the same Devant Mirage case. Now, my lords, you would have seen Justice Kangaloo in Afzal Mohammed, and in all these judgments, the alleged conflict between the rules and the act is one that has not featured in our jurisprudence. You will see that we were able to harmonize the interpretation, and it has not created any problems thus far. You will see it at paragraph 7 again. There is no conflict between section 11.1 and part 56.3. Rather, the combined effect may be summarized as raising three issues for the judge. whether the application is made promptly. If it was not prompt, is there good reason to extend time? If there's no good reason to extend time, leave should be refused for lack of promptitude. If, however, there's good reason to extend time, whether permission should still be refused on the ground that the grant of the remedy would cause substantial prejudice and hardship. So that's the tiered approach they take. Now, Lord, if I take you next to the dissenting judgment in Devant Mirage of Justice Appeal Jamada, this is the judgment we say is correct, and which we will be arguing in October in that appeal is correct, and that the majority judgment was wrong. We also say that the judgment in Absal Mohammed was not per incuriam, and that this court was bound by its own decision in accordance with the Young and Bristol Airplane case law. It was not open to the court to disregard a previous unanimous judgment by the Court of Appeal. Now, my lords, you will see that at page 5916, paragraph 23, Justice Jamada says, against this backdrop, at the top, against this backdrop, Section 11.2 of the JRA and Rule 56 are rational, reasonable, and can be construed as coherent. This is page 5916 at the top. Then paragraph 27, a purposive read at the bottom of the page, a purposive reading and interpretation of both provisions leads to the following. It is only when the delay is undue to be understood as unreasonable and any one of the other three 11.2 factors is operative should a court refuse leave. A fortiori should a court on the basis of delay set aside leave already granted. In my opinion, to construe 11.2 otherwise would be to undermine the clear statutory intent of the subsection. At minimum, there must be at least due consideration of Section 11.2 factors. Paragraph 29. The statement does not say that delay cannot deprive an applicant of permission to apply for judicial review. What it asserts, certainly in the context of 11.2, is that delay simpliciter without the likelihood of prejudice, hardship, or detriment ought not generally to deprive a meritorious application from proceeding. To this extent, I continue to agree that this is a correct interpretation of 11.2. The jurisdiction of and power of a judge to refuse or set aside leave is to be exercised accordingly. What is necessary is both balance and flexibility, oriented around a clear sense of purpose and intent in the context of constitutional values, the functions of judicial review, and the circumstances of each case. Ultimately, it's a question of an exercise of judicial discretion. Now, my lords, if I take you to page 5921.
What does he say about 11.1? 11.1 conundrum, as he calls it.
Well, my lord, if I can answer that by taking you to page 5921. You will see at paragraph 35, firstly, on 5918, that the judge, he says at paragraph 35, in my opinion, accepting that the function of these sections is interrelated, the use by Parliament of a completely different set of terms suggests that they are not to be subsumed one into the other, and that the tension between the two is also deliberately functional. At 5921 on to 5922, the judge takes time to set out the correct approach and basically says that there should be not a restrictive approach, but a broader range of considerations. And at paragraph 51, I think it's important to note his opinion. He says at paragraph 51, in my opinion, for the purpose of 11.2, there must be undue delay as well as the due consideration of hardship or prejudice or detriment before leave can be refused on the basis of undue delay. It may very well be that Justice Kangaloo overstated the position somewhat. This is at page 5923, paragraph 51. It may very well be that Justice of Appeal Kangaloo overstated the position somewhat. But in my understanding, the position is that there must at least be due consideration of all the factors that I've identified above. So, my lords, we don't say, as the judge says, and he was on the panel with Justice Kangaroo and Afzal Mohammed, we don't go so far as to say that absent prejudice and detriment, you must get leave. What we say is that there must be due consideration of these plainly relevant considerations in considering whether to extend time and, of course, in considering whether one should have leave. Now, my lords, if I take you to page 6047 of that bundle, to the judgment of Her Majesty's Board in the case of Fishermen and Friends of the Sea, Part 1.
Sorry, page?
It's at page 6047. It's at the back, 6047.
Thank you.
My lords, I take you to paragraph 23 at page 6056. You will see that the understanding of the court as to what the Privy Council did in this case, in my respectful submission, is wrong. The Privy Council did not approve of an approach that was blinkered, that said if you didn't have a good explanation or a good reason to extend time on the 11-1, that's the end game. The judicial guillotine did not fall on the neck of the application, as it were. And you will see that from paragraph 23.
Well, start at 22, perhaps.
Yes, please, Lord.
The second sentence. The FFS had to make out a case for an extension of time under Section 11.1.
Yes, please, my lord. And, well, let's see what happened. Mm-hmm. The judge asked himself whether there was a good reason for extending the time of the application, paragraph 23. He listed some salient points in favor of them, and then he listed points against them. Against this, and his conclusion, you'll see at the end of paragraph 23. But he considered the lapse of about 2 months from mid-March to the filing of the application was difficult to justify. He concluded they had not shown good reason for an extension of time under 11.1. But that was not the end game. And that's the point, my lord. You see at paragraph 24, the judge then went on to consider the two topics specifically mentioned in 11.2. Now, in the case for the respondent, they say that the judgment ends at the end of paragraph 23. There's no need to consider anything else. And we say no. And we say that they've misunderstood the approach even that was approved of by the board, because that's what's happening in Devant Mirage. The Court of Appeal is saying that the board approved of this compartmentalized and rather restrictive and blinkered approach. It didn't, because the judge then went on to consider two topics mentioned in 11.2. That is whether there be substantial prejudice to the rights of BP or detriment to good administration. And then you will see at paragraph 25, finally, the judge referred also to the public interest in the case.
Well, if you look at paragraph 26,
26, my lord.
The third sentence, we're told that Justice of Appeal Nelson correctly observed that the sole issue was whether Justice Barrot had properly exercised his discretion in refusing to extend the time.
Yes.
So that's the decision under Section 11.1.
Indeed, my lord. And if we look at what the Privy Council said at the bottom of that very page, as their lordships read his judgment, he expressed a definite preliminary view against granting the extension of time because of the unjustifiable delay. But he then went on to test that conclusion against other issues, including the public interest and the strengths and weaknesses of the FFS's case. Now, my lord, there'll be no need to go on to test that preliminary review against those matters unless it could have made a difference. And that's where the composite approach that we advocate comes into play. Or else if you find that there was no good reason to extend time, then that's the end of the matter. And we say, no, it's not.
Yeah. Well, forgive me, would it be fair to say that the board's approach here was to treat the relevant decision as being a decision under Section 11.1, 11.1 alone, but they approved of the judges having taken account of, as relevant considerations under 11.1, some factors which are mentioned in 11.2.
Indeed, my lord. And not just factors which were mentioned in 11.2, because the public interest is not mentioned in 11.2.
That's right.
But it supports our point that in 11.1, any material consideration, depending on the facts of the case and the issues raised for you, become relevant to the exercise of judicial discretion.
So a good reason is not necessarily confined, for example, to the conduct of the applicant.
No.
It can be a wider concept than
Indeed,
that.
my lord.
Yeah.
Because you can have a case where the need to vindicate the rule of law is so important having regard to the issues raised that should override the question of delay or conduct. The time capsule issue pales into insignificance when one considers what's at stake in the case itself, as of course arises in this very case before my lords. And my lords,
do you accept the approach to this case that we are essentially reviewing the exercise of discretion by the judge?
By the High Court judge, yes, my lord, because that's what's said by Lord Walker in the FFOS number 1. So we are reviewing. It's analogous to a renewed application for leave, if I may use that analogy, my lord.
Yeah.
My lord,
And in paragraph 32, they say that the judge's exercise of his discretion was not flawed. There is no reason to interfere with his decision not to grant an extension of time. So the only decision taken was a decision under section 11, subsection 1.
indeed.
And that was regarded as a discretionary decision, and it's clear that the judge took account of quite a wide range of factors in exercising his discretion.
Indeed, my lord. Indeed, I'm obliged. My lords, 11.4 says that you should have regard to the time when the decision was, when you became aware of the decision. Now, my lords, 11.4 in our jurisdiction, if I ask you to just look at it briefly, you'll find it in volume 13 at the beginning. And I take you to it only to point out, my lord, that 11.4 says, where the relief sought is an order of certiorari in respect of a judgment. I'm at page 5735 of volume 13. Where the relief sought is an order of certiorari in respect of a judgment, order, conviction, or other decision, the date when the ground for the application first arose shall be taken to be the date of the judgment, order, conviction, or decision. Now, my lords, in England, this provision is limited to a judicial or quasi-judicial decision. In other Caribbean countries, it is also so limited.
Is it?
Yes, yes, it is, my lord.
I'm surprised you say that.
You mean,
Surely it
but
applies
England,
to local authority decisions, or it applies to planning decisions by local authorities, for example.
yes, my lord. But
They're
I
not
believe
quasi-judicial, they're just administrative decisions.
yeah, well, my lord, yes, but in the English rules, I believe the way it's phrased, it's phrased in a way that quite clearly makes it relevant to what I interpret as judicial or quasi-judicial decisions. Perhaps we can take.
Well, we're not concerned with the English court.
No, we're not, my lord.
I'm surprised at what you say, because it's not my experience.
Well, my lord, the purpose that I bring you to this point, my lord. Look, it's anathema to the whole concept of fairness for time to run against a man when he is not aware of the decision that affects him. That is, it reeks of arbitrariness.
But that's taken into account at 11.3.
It is.
So there it is. So I would expect 11.1 to be dealing with a specific date.
Yes.
11.3, when considering whether to extend time, you can have regard to factors like knowledge.
Indeed. I mean, that of course, is consistent with the line of authority in Anri Fajeva from the House of Lords and the subsequent case in Unilever, where you must become aware of the decision in order for time to run against you. And that's the whole debate about whether the requirement to act promptly has a sufficient degree of certainty about it, such that it can comply with the European directives and law. But, my Lord, I make the point here because if time runs from the date when we became aware of the decision, i.e. the date when it was placed on the register, we actually filed our application within 3 months.
Well, we know that, but if that's not what the section says. Your 3 months runs from the date of the grounds. Subsection 4 says the grounds are the date of the decision.
Yeah.
And then subsection 3 says you can take into account the question of knowledge in deciding whether there's good reason to extend.
Sure.
What's wrong with that as a framework?
What's wrong with it, my Lord, is simply that if time runs from when the grounds first arose, when the grounds first arose in a case where there's a statutory duty to place something on a national register to inform the world that this decision has been made, in the context of a case like that, when there is that statutory duty, ought the grounds not to first arise when it is placed on the register, as opposed to an ordinary case that does not have the interposition of that statutory duty to give notification to the whole world?
Well, it depends how you interpret the section. I mean, there are plenty of sections which say that time runs from the time when it's put on the record.
But my Lord, in any event, we say that it was obviously highly relevant as to when it was placed on the record and when it came to our attention, in which case, my Lord, the 7-day period outside of the 3-month period would be easy to justify an extension of time.
We have to be careful. The 3-month period isn't an entitlement.
No, it isn't, Lord. I accept that. It isn't. My Lord, we've listed at paragraph 34 of our case for the appellant, we've listed the factors that we say in combination justifies the extension of time and the grant of leave. That's at paragraph 34 in the case for the appellant. I add only 2 points to that list, and we culled that list from the judgments in our favor in the courts below at the level of the Court of Appeal, from the unanimous judgment of the differently constituted panel that granted leave, the judgment of Justice Narayan, and the judgment of Justice Rajkumar in the Court of Appeal when the first interim injunction was granted. We add to that list today only one, and that is the conduct of the EME. And the conduct of the EMA, my lords, I'd like to take to volume 5 to just illustrate the point briefly. Volume 5, page 2361. It's at the very back. It's the last page at the back in volume 5. This is the response to the Freedom of Information request. And the request is set out, request number 1. Documents required. All reports, reviews, assessments, and other documents prepared by the EME, its external consultants and the experts in relation to the processing of the CC application and the grant of the CC. And their response, all documents related to the processing of the CC prepared by the EMA can be located on the National Register. And my Lord, that statement, quite frankly, is misleading. It is false and incorrect. Because the internal memos...
Sorry, can you give me the page again?
Oh, beg your pardon, my Lord. It's volume 5, page 2361.
2361, sorry, thank you.
And I'm saying the response to the Freedom of Information request was false and misleading because it gave the impression that what is on the register is it's all on the register, when it wasn't. Because as we see from the internal memos, which demonstrated that there was a virtual intellectual revolt within the EMA against the directive to grant the CC, that was not disclosed. Under the freedom...
Is it, I know you rely heavily upon
yes,
the technical officer's document. Is the document clearly within the terms of your request?
We say so, yes, my lord, because the request asks for all documents related to the processing of the CEC prepared by the EMA, and when you look at the title of those documents, it actually is the processing unit and the clearance unit. They were directly relevant to the processing of the CEC application. They did not disclose the existence of the documents and claim an exemption under the Freedom of Information Act, which they could have done. What they did was to seek to what we say is deliberately mislead by saying, well, look, it's all in the register. It wasn't.
Thank you.
And my lord, further to that, we say, we say that you will see, just immediately before the works commenced, the last thing was that they were awaiting a regional corporation approval. That's the last thing they said in an email to the court when we saw the notice saying works will start. My lords, that regional corporation approval is not in evidence, has never been disclosed to the court. We don't know what were the terms and conditions upon which that approval was granted. We don't know if it was granted. And you will see the rather cryptic manner in which their response was drafted to the court. It certainly does not comply with the high duty to make full and frank disclosure on the part of a public authority.
Which document, which email is that?
My lord, that is an email. It's to be found, my lord. I'll come to it. I'll come to it, my lord. I have the reference later on here.
What's the date of it?
The date of the email. What's the 22nd of December 2017.
I mean, don't let's forget, we're talking about the lawfulness of a certificate dated, is it 22 June or something?
Yes,
like
please,
that?
my lord. Yes.
I mean, you're throwing in a whole lot of stuff, later stuff, that you think was wrong. But, I mean, can that really go to the lawfulness of the June certificate?
Well, my lord, the answer is yes, because what the evidence demonstrates, my lord, is that on the very day the certificate of compliance was granted, you have these internal memos in all 7 very highly qualified experts within the EMA who were instructed, they recorded that we have been instructed to grant the CEC by lunchtime today. And every single officer who received that strange oral instruction from a politically appointed person through a politically appointed board in respect of a government project says we all record our vehement objection and say that this is wrong and can't be done and should not be done. And they give, speaking with a unanimous voice, they give credible, hard evidence as to why they object. They say the attempt to conditionize matters...
So where are you referring to now?
That's the internal memo, my lord.
Page?
It's at volume 6, page 2372, straight on to 2376. Can I take you to it now, my lord, seeing that we're on it? Give me the answer, please, Alvin. Volume 6. Page 2372. Are you with me, my lords? It's volume 6, page 2372. And you will see, my lord, this is the assistant, in the second column, assistant, this is the CEC clearance unit approval form. Ms. Giselle Joseph, Assistant Manager of Technical Services, the Manager of Technical Services, the Administrative Officer, summary of decision. The CEC is prepared in accordance with the following instructions from the Managing Director. On quote, open quote. Please complete your review with the officers by Tuesday lunchtime and advise me of how you will be addressing the conditions in the CEC. Inherent in that instruction is a presumption that they have to grant the CEC.
Why?
because he says, please complete your review and advise me of how you will be addressing the conditions in the CEC. And then the next line, I expect I will have a CEC for signature by Thursday, 22nd, 2017. By lunchtime on Thursday, he demanded a CEC in respect of this matter. And this is what the technical officers had to say. 1, a proper baseline assessment has not been conducted. Such an assessment forms the basis of any environmental impact assessment. See detailed review response to the area. I do not agree that a CEC should be issued for this project at this time, since the majority of issues highlighted in the first area have not been addressed satisfactorily by the applicant. This is the general consensus of the technical team. The managing director instructed that the documents not be subject to review by other agencies who formed part of the review team. Why would the managing director instruct that the document not be subjected to review by other agencies who formed part of the technical review team? Because of this, there are certain sections of the response that have not yet been reviewed, since the competency lies within the respective agencies. So the remaining people who had to comply with this instruction said, we don't have the expertise, and you've instructed us to exclude those who have the resident expertise. The managing director instructed that the document not be subject to public review. Based on the nature and location of the project, as well as the public interest, I strongly disagree with this decision or instruction. Pertinent concerns were raised through the public comment process, and as such, it is only fair that the public be privy to all information in response to their concerns. We've done this in the past. While an instruction to prepare CEC was received from the MD, it should be noted that several details regarding the scope and design remain outstanding, and as such cannot be addressed through CEC conditions. An attempt was made to prepare CEC to cover the major issues. However, the placement of conditions such as baseline information is contrary to good environmental impact assessment. We should be mindful that this project is in close proximity to a designated ESA, which is inhabited by at least one endangered species. To this end, it is my technical opinion that the precautionary principle in the consideration of this project should be applied. See note to the definition. Paragraph 6, the potential range and magnitude of impacts will inform more monitoring strategies, and the assistant manager's comments below. It is highly irregular and unprecedented to issue a determination for a CEC application for which there are significant outstanding concerns to be addressed based on the requirements of a TOR that was issued for the conduct of an EIA in support of the application. I am in disagreement with the instructions given, considering that a complete review of the information by the established review team was not afforded to ensure a proper review of the report and adherence to the established process and proper practice in making a determination. This project is highly sensitive due to its location. And like all other similar applications, proposed highways and their alignments, we have reviewed and received same. Last line, I am deeply concerned about what we will be able to include in any final action, notice final action for this application to justify the final decision to be issued. Then we go to page 2375, another committee, the review committee file assessment form. Could you get this way, please, where we paraphrase this? And at para 141 of the case for the appellant, we have transcribed this for ease of reference. So at para 141 of the case for the appellant.
Sorry. Where are we going?
141? Yeah. Is that what you'll see, my lord, at para 141 of the case for the appellant. No, that's not it. No, that's not it. Oh, it's at 144, beg your pardon. It's at 144. And these are three different officers. You will see at 2375, it's a legal officer, the compliance officer, and a technical officer. And what they say, with respect on the technical detailed review and recommendation. The RAR response is deficient, requires clarification as well as public comment. This follows good practice which the EMA has observed in assessments of similar nature, size, and location. So, my Lord, you will see when you read the transcribed version or the handwritten version, whichever you prefer, that this was another committee expressing grave concerns about receiving an instruction and a directive. So if you can read paragraph 144 in the case for the appellant in its entirety, you will see how rooted, how strong, and how aggrieved these officers felt about what they were being asked to do. And what were they being asked to do? So, my lords, what we say is that the officers were objecting to the instruction. They were being asked to put matters as conditions to the grant of the CEC when those matters were critical success factors that had to be fed into the nodes of the decision-making process that leads to the decision of whether one should grant a CEC or not. These were not conditions which could be attached to a CEC ex post facto. These were matters that had to be considered before you could decide lawfully whether to grant a CEC or not in the exercise of your statutory discretion. By conditionizing them ex post facto and relegating them to the periphery in such a manner, what the decision was fundamentally flawed. It's a bit like going for a driver's license and saying, look, I'll give you a driver's license on the condition that your eyesight somehow improves. I mean, it's too fundamental a consideration to the exercise of your statutory discretion. And it could not be fairly exercised in a lawful manner, given the pith and substance of these objections. Now, my lords, now, my lord, on the issue of prejudice, thanks, Richard.
Okay, sorry, where do you leave that? I mean,
Well,
what the judge said about it was that they were expressing their opinion, but the relevant decision maker had to consider that and make his own decision.
Well, my lord,
And he did.
it's relevant to the it's a material non-disclosure in response to an application under the Freedom of Information Act, and the conduct of the defendant is yet another example of irrelevant consideration that a court should properly have regard to when exercising its discretion on whether to extend time and whether leave should be granted. The conduct of the defendant, the public authority, is a relevant criterion to which the court should have regard in an appropriate case such as this in exercising its judicial discretion on whether to extend time and grant leave.
Was that how it was put to the judge?
Well, my lord, yes. We have been arguing.
The problem with the judge, he said, he didn't have any evidence from you as to why you hadn't complied with the time limit. I mean, I don't think there was any evidence saying we couldn't comply with the time limit because we were desperately trying to catch up with our freedom of information requests and they were misleading us.
No, but what we did say, my lord, is that in the chronological sequence of events, when this document was dropped off at the office of the appellant, that obviously would have had an impact in terms of how the preparation of the case.
Yeah, but was this a point you made? You made this point in the context of irrationality challenge. I understand that. But you didn't say this was such a bombshell that it delayed our preparation.
Oh, no, my lord, we did. Oh, no, my lord, we did. We did. We also made the submission.
Was there evidence saying that?
Not in evidence, but we made it. It is self-evident from the chronology itself that this is a bombshell, and yes, it would have caused or contributed to some measure of delay in the preparation of the case. It came after the pre-action, the exchange of the pre-action letters, and was a belated disclosure after a prolonged period of non-disclosure. Can I quickly go to the question of prejudice and say this, my lords? If I take you to volume 11, and one second, let me just, if I take you to volume 9, sorry, beg your pardon, yeah, volume 9, and I take you to page 4335, now, on the prejudice point, to summarize our position, at the time we filed the application for leave, precious little was happening. They were fighting to try and comply with the conditions imposed on the grant of the CEC. No work had started, unlike Bakongo, unlike Fishermen and Friends number 1, where the project was almost completed. This is an exceptional case. I have not been able to find in my research any case where they were able to capture the developmental process at this stage. No work had commenced at the time the application for leave was filed, because as you would imagine, they were trying to comply with the conditions, the very serious conditions on the CEC. What happened afterwards is that they surreptitiously attempted to steal a march on the applicant while the application was pending in the face of the court, and whilst representing to the court that there was no urgency about this matter. And I want to show you that now, my lord. Because consciously manufactured prejudice that is self-serving and designed to utilize and exploit a window of opportunity created by adjournments which you've requested to be for long duration, just can't be entertained in the context of prejudice and detriment. I take it to paragraph 4334. This is the first case management conference. It's on the 5th of October 2017. And at page 4334, you will see at the bottom of the page, Ms. Batiste Mohammed, appearing for the ministry, says, I do appreciate the court giving us a chance to speak. There are some procedural issues that have to be finalized as between the Ministry of Works, NIDCO, and EMA. I know the court's question was whether or not this matter was really one of urgency. And she says at the bottom of the page, there are certain procedures that have to be completed on the CEC, one of which is the baseline survey that has to be completed. Next paragraph, the other matter is the environmental management plan. I don't foresee, my lord, that there should be any real urgency in this matter. And more importantly, the contractor, that is between NIDCO and the ministry, the contract has not yet been signed. So the contract between CALCO and the ministry had not yet even been signed when the matter came up first for hearing. And I suppose once we've had all these issues finalized, then they would have to have negotiations. I would suggest, my lord, we revisit the issue maybe within the next 6 weeks or so. And then she says lower down, so far as for the interim application, interim injunctive relief, there isn't going to be anything taking place. I believe at least not for the next 6 weeks. We then go to the next case management conference, page 4347, which is on the 2nd of November. Page 4347. You will see at page 4346 at the very top, 1, 2, 3, fifth exchange, Mr. Benjamin. Oh yes, the court was saying, so I think to be fair to the intended claimant, in terms of urgency, any urgency, the claimant may not be in possession of the relevant fact, but the necessary facts. Mr. Benjamin says, oh yes, but all I can say to you, my lord, now based on the limited instructions I have, there is no immediate intention to begin works. We are not there yet. The court says yes. He says, least of all, for the reason that the CEC conditions have not been fully complied with. Across to the page, if you just walk your fingers across, you'll see the court speaks, third exchange. I was going to address that, but I say there seems to be little likelihood that this matter, when I say this matter, I mean the construction with which the intended claimant objects, will be commenced at any short period of time. And they want to put in some evidence too in relation to the application. Page 4348, in the middle of the page. Mr. Benjamin. Correct. So I mean, I'm going to take my instructions, but if we put in any affidavit material, we could certainly do so perhaps within 4 weeks. Nothing urgent is happening. Give us a month. Would that meet with your Lordship's approval? Well, of course it did. Now, Lord, the next thing that happened is that we go to the email to the judge at page 4068. Because after that exchange, what transpired was an advertisement appeared saying works was to commence.
Well,
and this is at page 4068. When that advertisement appeared, Mr. Abood wrote to the court. And this is what happened. The ministry writes to the court.
Can we just see the email? 68.
4068, madam.
And this is dated?
It's dated the 22nd of December, 3 days before Christmas. This is the email. It says, because we had objected, and it says, whilst the claimant did not ask for such an undertaking, the interested party informed the court on the 2nd of November it was not in a position to start works because the terms and conditions of the CEC had not yet been complied with and final approval from the EMA had not yet been obtained and no contract had been signed with the contractor. Since then, as disclosed in our affidavit, NIDCO has complied with the requirements of the terms of the CEC. Further, EMA has issued an approval, final approval of the CEC, and further since then we've signed a contract for package 1 with the contractor on the 20th of December. Why are you going ahead and signing a contract with the contractor when you know that the application for leave is pending is beyond me?
But why shouldn't they?
Well, my Lord,
I mean, if they believe their project is important and is lawful, then there's no reason for not to get on with it.
That's one way to look at it, my Lord. But wouldn't it be better, wouldn't prudence also equally dictate that you perhaps await judicial determination or see what's happening with the application for leave?
Well, it depends on all sorts of factors.
It
They
would,
have
my
to
Lord.
make a judgment.
I shan't press it, my Lord.
Yes.
I shan't press it. But this is what they say, my Lord. We've signed the contract. However, the Ministry of Works has not received regional corporation approval. Thus, the ministry is not yet in a position to seek commencement of works until that approval has been provided. The next thing that happened after that is on the advertised date, which was a day after New Year's, which is a public holiday in Trinidad, which is January 2nd when the works were to commence, nothing happened. Works did not commence as advertised.
That's what they're saying here.
Well, no. What they're saying here, this is the dated December 22nd. I'm saying that on the advertised date when the works were scheduled to commence, which was January 2nd, nothing happened. Works, however, did commence on January 8th.
So I'm not understanding this. This letter says they're doing various procedural things. They've signed a contract, not able to start commencement because they haven't got regional corporation approval.
Yes.
Is that accurate?
That's accurate.
Yeah.
And the short
And then
point
nothing
is,
happened,
but,
as one would expect.
Indeed, my Lord, but if something changed, such, i.e. if you got that regional corporation approval, having regard to the representations to the court and to the appellant, the duty to make full and frank disclosure, which is a continuing one, would have at least mandated that they inform the court that, look, we've got this outstanding regional corporation approval and all systems go.
And when did they get that?
No one knows. They never told us, and it's not in evidence. It's never been disclosed, and that's the point.
It's never happened. Has it ever happened?
Well, we don't know.
So what are you complaining about?
Well, I'm complaining about the fact that one can infer, presumably, in accordance with the presumption of regularity, that they did get it, because it would be a far more serious matter, my Lord, if they commenced the work without that approval.
But they didn't commence the work.
They did.
Well, but yeah, they eventually did. But in the meantime, you hadn't made any application to the court for an injunction.
No, we did not, my Lord.
And you hadn't obtained any undertaking.
No, and we didn't, my Lord, because the prevailing state of affairs, the status quo was such that, as had been represented to the court, approvals were outstanding. First it was the compliance with the conditions of the CEC, then it became this issue about the outstanding regional cooperation approval, and we've thought that, my lord, in accordance with the duty to make full and frank disclosure, if that changed, we would have been notified, and we think it's a legitimate expectation.
Well, the last hearing, I mean, as I understand it, the case had come on before the judge shortly after the application was filed, and he had adjourned consideration of it to the 2nd of November. And we saw what Mr. Benjamin said on 2nd of November.
Sure.
And his instructions covered a period of, I think, looking ahead 4 weeks. So, I mean, once you're into December, your clients had not been given any assurances about what was happening.
Oh, that's true, my lord, I accept that, but my lord, my lord, this point goes to prejudice. It goes to prejudice in that they can hardly complain about prejudice, my lord.
Right.
I'm obliged. Given that they were the ones who consciously took steps that could be considered prejudicial to them in the face of the application pending.
Yes, yes.
And it
Yes,
also
so you
goes
say
to
they acted at their own risk.
Indeed, my lord, indeed. And it also goes to the conduct of the defendant, which we said again was a relevant consideration in, that should be, to which regard should be had. My lords, so we say a self-inflicted wound cannot give rise to a plaster at the instance of the appellant. Yeah. Now, my lord, can I then quickly go to Rule 5, the pre-TR consultation point. Now, my lords, in that, you will find Rule 5 in the volume 13 at page 5768. Rule 5 is linked to the sub-rule D above, which is 4D. And 4D deals with the processing of the application. And you will see at 4.1D, you're to notify the applicant that an EIA is required in compliance with a TOR. So the TOR is a very important and crucial document. Then we see Rule 5. Where the authority determines that the EIA is required, it shall, within 21 days, consult with the applicant on the preparation of the TOR. Now, my lords, this is an important step because the views of the developer is taken into account because he's consulted in the preparation of the draft TOR. It's then prepared, the developer is notified, and then this is what is said. The applicant shall, mandatory, where appropriate, conduct consultations with the relevant agencies, NGOs, and other members of the public on the draft TOR. Pause. Query. The applicant shall, mandatorily, where appropriate. Who determines when it's appropriate? That's the first question. Secondly, is it disjunctive such that we pause there to say that whoever determines it's appropriate, once it's determined that it's appropriate, this consultation shall take place?
You've got such little time. I'm really worried about you and Mr. Ward.
Yes, indeed. So am I, my lord.
We've studied these subsections in detail. One, why was it appropriate for you to be brought in on this pre-TOR consultation? And two, what was wrong with the TOR as originally drafted and as eventually signed off? Do you mind my asking you to focus on that in the light of the time factor?
Not in the least, my lord. My lord, if I might say, my lord, it would not be correct to answer those questions by a speculative analysis with respect. What I say, my lord, is this. What we do know is that if the law required consultation in accordance with the correct interpretation of Rule 5, or in the alternative, if the EMA directed that consultation take place at the pre-TOR stage, the issue is not what those consultations might have yielded. The issue is whether the consultation took place lawfully in accordance with the law. Now, in this case, what we do know is that the EMA, in its letter, the EMA directed that pre-TOR consultation take place. And you couldn't get that clearer than from the affidavit of Mr. Romano himself. And Mr. Romano's affidavit, which is very clear in its terms, says that they directed that there be consultation. You will see this in volume 7, quickly, my lord. Volume 7, page 2934. Obliged. Paragraph 24. This is the managing director of the EMA, and one would have thought that he would know what their policy, practice, and procedure is.
Yeah, but assuming that's right, assuming they wanted consultation, but it didn't happen, you are here complaining about it, and my Lord has asked you, well, what was wrong with it, and what was your complaint? I mean, you know, we're dealing with your interest as objectors, very experienced objectors.
Yeah, well, my lord, the complaint is that if consultation was mandated and it didn't take place with two critical groups...
Yes, it may be a technical error, but we're dealing with the substance of the matter. Is this a reason for extending time? Is it a point of real substance? And we're entitled to ask you, well, what was wrong with it?
Well, my lord, with respect, I don't think that a breach of the consultation process is cured by asking what would have been different. It's like a breach of natural justice. Whether or not the same decision would have been arrived at is not an answer to the breach of procedural natural justice or substantive natural justice. In this case, what the authorities show in speaking with one voice is that if consultation is mandated and required by law, and the process is embarked upon, you've got to have it done. It must be done lawfully. It must be genuinely and meaningfully done. And this is a case where there was an omission to consult. It is not a case of inadequate consultation. It is a case of an omission to consult two critical specified groups. And those groups are the affected communities and NGOs.
But you haven't yet addressed the question of whether it is obligatory to have such a consultation. Because leave the letter to one side for a moment,
sure.
If it derives from the Act, then it has to happen where appropriate.
Sure.
And I haven't yet picked up why it's appropriate in this case.
Well, milady,
on your case.
Yes. Well, milady, we say it was appropriate because, firstly, the EMA, which is the agency charged with giving the statutory mandate, felt it was appropriate and mandated it, as can be seen as is evident from paragraphs 24 and 25 of Mr. Romano's affidavit. And it is not for the court to substitute its own discretion for that of the public authority. The fact of the matter is, the public authority, whether we agree with it or not, it chose to mandate public consultation at the pre-TOR phase. We say that is consistent not only with its policy and practice, but it's also consistent with Rule 5.2. Rule 5.2, we say, where appropriate, could be interpreted as meaning where the authority thinks it's appropriate and it so mandates that the consultation takes place. There may be many issues that one could have raised at the pre-TOR consultation process, that the baseline studies, cumulative impact assessment, the endangered species, the ocelots, the impact of traffic and congestion, and a range of things that we can speculate about. But one can see, given the problems which surfaced during the RARs, the reviews, those problems may very well have been avoided had there been consultation at the TOR phase, because the TOR would then have properly informed the EIA the TOR being the template that informs the EIE. But, my Lord, a speculative analysis, in my respectful submission, is not the answer. It is a question of whether the omission to consult these groups was lawful, or did it render the consultation process fundamentally flawed and defective. I can't say what the affected community of fishermen, the affected community of people who live in that community, who see ocelots in their backyard or whatever. I can't say what they would have said at the pre-TOR consultation. But there are issues, fundamental issues, that is borne out by the evidence in terms of the problematic application and the series of RARs that could have easily been raised at that phase. In particular, the cumulative impact assessment. There was no attempt to have it modified at the TOR phase, and that would have been an issue perhaps that could have been sought at the TOR before it's finalized. That would have avoided some of the problems later on. So, my lords, that's the answer to Rule 5. And, my lords, we say that on a correct interpretation of Rule 5, it must surely be that it can't be for the developer in his sole discretion and judgment, if he desires a modification, to embark on consultation. And we say so because, remember, when the TOR is drafted, his views are taken into account because he sits with the EMA and they draft it together. So that we say it's a chicken and egg situation. It is the consultation process that will inform the developer's thinking on whether there is need for a modification. It's not the other way around. He has to have that consultation process. And it is out of that consultation process would emanate something that may or may not give rise to a need for modification. So, my lords, those are my submissions. My lord, before I take my seat, I took a bit longer. We have a long distance to travel. My little friend, Mr. Wall, does have two important points, and I'd ask you to give us for a little leniency in terms of time. I'm obliged.
Thank you very much indeed, Mr. Remlogan. Mr. Wald.
My lords, my lady, perhaps given the time, it would be sensible just to have a word about the timetabling of the remainder of the proceedings. I anticipated taking about an hour. There was some debate about allocation of time. We've agreed an allocation that has us finish in about 6 minutes.
Yeah.
That won't be possible, and we are obviously anxious to provide as much assistance to the board as can be provided. Having seen the written cases from the respondent and interested party, it is apparent that there is a significant degree of duplication in their two cases.
Yeah.
It may be therefore possible for the board to indulge a little overrun, or else I don't know whether it is ever possible to sit rather slightly later than the 4 p.m. cut-off.
As I mentioned earlier, we're keeping open the possibility that the board might be able to announce a decision today.
Yes.
That would seem to be helpful to everybody.
Yes.
If it's possible. But that would involve us going off the bench and discussing the case and then coming back on again.
Well, I know that the case was originally listed for 2 days. Can I take it that tomorrow is unavailable now?
Subject to checking, I think you probably can. It was put down provisionally for 1 to 2 days because it was originally not clear whether the board was going to be asked to determine the substantive issues on the JR.
Indeed.
And once it was decided not to do that, the case was set down for 1 day, and obviously you've taken, your time has been used up pretty much. But I take your point about there is some overlap between the case that Mr. Knox will be presenting and the case that Mr. Benjamin has. It may be that there's room for some discussion over that.
Well, my lord, shall I make a start and we'll see where we can get to over lunch?
Yes, sir.
My lord, I anticipated needing to move at pace, and I've therefore provided a 4-page list of references. One can, on the basis of that, know in advance that I'll initially be referring to volumes 1, 2, 3, 4 and 13. And that takes us roughly to the halfway point, at which point I'm going to suggest that we clear the decks and get hold of the other volumes. So those are 1, 2, 3, 4 and 13. My lord, I'm dealing now with the latter two grounds. whether it was the courts below erred in holding that the EMA was entitled to grant the certificate, notwithstanding the absence of a cumulative impact assessment in relation to the highway when taken together with the proposed continuation of the road beyond it, and then lastly, whether it was rational and or not ultra vires and or not in breach of statutory duty for the EMA to grant the CEC with conditions, which includes granting it at all, in spite of the objections of their own technical staff. And we've looked at those objections, so I won't need to spend time on that. Yeah. My lords, my lady, by way of brief introduction, 3 preliminary points. First of all, the CEC was granted without any approved EIA, and I think it's important to emphasise that. There were no fewer than 3 EIAs in this situation. We've not seen the first, we saw the second, but that was subject to extensive criticism in the RAR, the review mechanism by which the EMA indicates how, if appropriate, the EIA in question falls short of the requirements of the TOR. And that's important to bear in mind. The TOR, the terms of reference, set the parameters for what must follow in the EIA. So all the identified deficiencies in the EIA amount to an indication that the requirements of the TOR had simply not been met. And we'll look at those in a moment. Not all of them, just the key examples of it. The fundamental problem for the EMA in this case, from which other problems flow and which give the necessary context for them, is the undisputed fact that the CEC was granted without production, publication, or consultation upon any defect-free or finalised or approved EIA. That's important to bear in mind. The third EIA postdates the CEC decision by almost 2 months. It was not considered by the EMA at all. The respondent and interested parties contend that EIAs 3 and 2 are materially identical, but not that the former predated the grant of the CEC, and that's why it's an agreed matter. The first 2 EIAs were the subject of significant criticism by the EMA. We've not seen the first EIA, as I indicated, but we know that the ministry was sent back to the drawing board and produced a second one. We know that the ministry was told, principally through the RAR, or the Review and Assessment Report mechanism, to go back to the drawing board once again because the documents did not conform to the requirements of the TOR agreed between the 2 parties, and upon which no modification was sought. So, my lord, my lady, you will have noticed that both the respondent and the interested party pray in aid of their position that no modification was sought, and therefore no consultation was required under the pre-TOR finalisation stage. But the fact that no modification was sought is highly relevant in our submission. It's relevant because the terms of the TOR were open to negotiation. They were initially hammered out through a dialogue between the EMA and the ministry. There was then an opportunity to modify if the ministry saw fit. It did not do so. It signed up to the requirement of a cumulative impact assessment. It signed up to the requirement of baseline studies in advance of the grant of any CEC. But it did not produce them. And it was allowed not to when the CEC was eventually granted in advance of seeing any approved EIA or any approved EIA being the subject of any consultation.
Hang on a moment. I got the point we're on to is cumulative impact assessment.
No, I'm bringing 3 preliminary points. The first and the most...
I know, but the point what we're concerned about in the 6 minutes you've got
yes.
are the grounds which you're advancing, not all sorts of other grounds.
No, I'm not pursuing cumulative impact assessment at the moment. I'm identifying 3 central points to the case. The first is that the CEC was granted without the benefit of any EIA that had been approved or had had the benefit of public consultation. The second is in relation to factual disputes, and the third is in relation to the volte-faces that we see, both from the EMA and the ministry. I will then move on swiftly to deal with those points one by one. Cumulative impact assessment comes a little later, my lord. I can deal with it now if that would be preferable.
I mean, that's the issue you're on, isn't it?
No, it's not.
That's the issue.
No, my lord, it's not.
Oh, I'm not understanding this case.
My lord, I'm taking those two issues.
You say these are 3 big points.
These are 3 big points that set the context for the rest.
Form the background
Absolutely.
to these specific points. Very well.
And the biggest point of them all is that the EIA that has not yet been approved, but resulted from a very extensive list of identified deficiencies in EIA 2, was not considered at the date of the grant. And that is a basic problem. It's a basic problem because...
But that wasn't a ground of the challenge before the judge.
It wasn't a ground.
I mean, that's what we're dealing with, an appeal from the judge. We're not dealing with all sorts of new points.
Well, it enables, whether the board decides to accept it as a ground now or not, it is vital context because it informs everything else.
Well, it isn't a rehearing of the leave application. And we're concerned with whether or not there was an error of law made by the judge.
Well, my Lord, I understand that. It need not be a ground. I understand that it's within the power of the board to consider it as a ground, notwithstanding that it was not raised before.
Not at 5-1 on the last day of term.
Well, in any event, it is highly material context because it leads to an understanding of why it was that throughout the process, the EMA was insisting on the production of baseline studies and insisting on the production of a cumulative impact assessment. And then, within the last 2 weeks of this process, had a change of heart. And we know of that change of heart because Mr. Romero, who had previously in his affidavit evidence been insisting on adherence to all of this, and insistent that the EMA supervise the process, was suddenly happy to go without any of those requirements.
Well, the court's going to adjourn now. The position is that you've used all the time for which you indented. If Mr. Knox and Mr. Benjamin are generous enough to allow you any more time, that's entirely a matter for them. But so far as the court is concerned, you asked for the time that you've been given and you've now used it. So we'll adjourn and sit again in an hour's time.
My Lord, may I ask, we have a reply. Would it be possible to use some of that time in continuing submissions?
Yes, certainly it would.
And is the board able to indicate when it is prepared to sit to today?
Well, we'll consider the matter over the adjournment, but my inclination at the moment is that we should sit for the normal time of day because we're then going to have to discuss this case to see whether or not we're able to give a decision. And we're not going to reach that decision in 5 minutes.
And finally, my Lord, that question that was raised, it may not be possible, but whether there is any possibility of a continuation into tomorrow.
Well, we will discuss that also, but I wouldn't hold up much hope for you. I mean, the case is down for today, and that's that.